right, well, hello everyone. Let me get started. Welcome to this session of the Faculty and Staff Workshop Series. It's being presented by the Collaborative Outreach Team and the Division of Student Success. The purpose of this series is to help you support the needs of our students. So we know that our students face a variety of challenges and issues, and to answer these issues and challenges, the university has many programs and resources, but those resources only work if our campus community has access to them and knows that they exist. So with this series, we're hoping to provide you with information necessary to help students, navigate any obstacle that they may encounter. Today's session's on Title IX. My name is Blake Bombard, and I'm the Title IX coordinator here at UT Tyler. Joining me as co-host is our Associate Dean of Students, Kim Livingston Cobb, who will be assisting by monitoring the chat function for any questions that may come up. So let's get started. I'm going to share my screen with y'all. All right, so I think you're going to see that there. All right, so today we're going to be talking about Title IX. What Title IX is, what it requires, what our obligations and responsibilities are under Title IX. So when we talk about Title IX, we're talking about Title IX of the Education Amendments of 1972. That's the federal law that prohibits any discrimination on the basis of sex at any educational institution. So it applies to K through 12 as well as higher ed institutions. At its inception, Title IX was primarily about gender equity. We want to ensure that both males and females have equal access, equal opportunity to a university's or an institution's programs, education, and activities. And that's still, a focus of Title IX today. However, over the years, Title IX has kind of been expanded to include other things, such as sexual harassment, then sexual assault, and most recently, dating violence and stalking have all been included under the Title IX umbrella. Title IX is overseen by the Department of Education, and they're the ones that provide us guidance on what Title IX means, how it applies, what's covered, and how universities, what the university's obligations are under Title IX. The way that the Department of Education communicates that to us is they send us a letter. That letter always starts off, "Dear Colleague." So those letters are kind of known as Dear Colleague letters. Excuse me, got an alarm going off. I apologize for that. Our building's DSL, so when weather alerts go off, that's the alarm we get. So sorry about that, I'll continue. Yeah, the way that the Department of Education communicates with us is through a Dear Colleague letter. And there have been some significant Dear Colleague letters that have come through. 2001 was a significant Dear Colleague letter addressing how universities must respond to allegations of sexual harassment. But the most significant one was in 2011, where the Obama administration really set down some very specific rules and processes that universities had to follow in response to any type of sexual violence or sexual assault. Then 2016 came along, and we had a change in executive administration in Washington, D.C., and some changes in how universities, we had some significant, we had a change in 2016 with our executive administration in Washington, D.C. And one of the things that they did in the Department of Education is they rescinded a lot of this guidance that came to us through these Dear Colleague letters. And the reasons that they gave for rescinding that were, they had a number of reasons, but one of the primary reasons was that these guidance letters were being used as though they had the effect of law. Universities were being punished, disciplined, fined for not complying with this guidance. And the Department of Education said that shouldn't occur because this guidance has never gone through a proper rulemaking authority. So what they did is they rescinded those rules, and they began the process of revamping and rewriting and giving the force of law behind the regulations and how we respond to sexual violence. That was about a 2-year process. Earlier this year, Back in May, those rules were finalized. They were open for public comment, and they are now in effect. They went into effect August 14th. And so now we have new rules that have the force of law that tell us what we need to do. Some of the things have not changed. Our primary responsibilities, our primary obligations, which are how do we prevent these things from occurring? And then how do we respond to them when they do occur? And our obligation to report, those things are the same. But some things have changed, and there's been some significant changes, and we want to discuss those. We want to talk about those today and what they mean for us as employees, and for the guidance that we give to our students, letting them know, letting them have the best information so they can make a decision on what they want to do. So the first thing that has changed in the new Title IX regulations is what triggers a university's obligation to respond. In the past, it was if the university knew, that means they had actual knowledge, or they should have known, which means they had constructive knowledge, then they had an obligation to respond. The new regulations have limited that to actual knowledge, basically saying we're not going to hold universities responsible for items that they actually did not know about. So under the new regulations, we do need to have actual knowledge that something has occurred. And actual knowledge means that needs to be reported to the Title IX coordinator. We've kind of taken care of that here in Texas with our SB 212 that we talked about last year, which mandates reporting for all employees of an institution. Those reports come directly to the Title IX coordinator. So the university does have to have actual knowledge that something has occurred. It's been either reported to the Title IX coordinator or to someone in administration who actually has the ability to take corrective action. So that's the first thing, is that's what triggers a university's response, an obligation to respond, is they need to have actual knowledge that something has occurred. So this applies to student employees as well. I want to make that clear. This is not just a student law, but this is an employee law as well. So Title IX covers both. The second thing that changed in the new regulations is the jurisdictional framework for Title IX. So in the past, if something occurred, for example, off campus, say there were a sexual assault between two students at an off-campus location, that was covered under Title IX. The new regulations say that is not necessarily covered under Title IX. It's going to depend on if it occurred within the context of the university's educational program or activity. So if you consider assault that occurs at a off-duty university organizational event, that would be considered within Title IX's jurisdiction. Does that mean that these things that no longer fall within Title IX's jurisdiction that the university is still not going to respond to them? No, it doesn't mean that. And there is a process for handling those types of cases that we get that maybe no longer fall under the definition of Title IX. So that is the other significant change, is that it has to be sexual harassment that occurs within an education program or activity. It has to occur in the United States. So when we consider our study abroad students, if something were to happen to them overseas, it would not be covered under Title IX. It would still be covered under the university's policies and processes, and we're going to talk about those a little bit later. And then the third significant change to the regulations was the definition of sexual harassment has changed. So in the past, sexual harassment was described as any unwanted conduct of a sexual nature that was persistent, pervasive, severe, or objectively offensive. Under the new definition, it's kind of raised the bar on what constitutes sexual harassment under Title IX. Again, even though it may not rise to the Title IX standard, we still have processes for dealing with things internally through university policies. But basically it says that it has to be unwelcome conduct on the basis of sex that is so severe, pervasive, objectively offensive. The key word there is and. So in the past it could be persistent, pervasive, but maybe not severe. It would still consider sexual harassment. Under our new regulations, you have to meet that standard of all three. It has to be severe, persistent, pervasive, and objectively offensive. So what are we talking about other than sexual harassment? I mentioned earlier, Title IX also covers sexual assault. So when we cover sexual assault, that encompasses such thing as rape, fondling, which is the touching of private body parts, honor beneath the clothing for sexual gratification, incest, and statutory rape. Dating violence and domestic violence were recently added to Title IX protection. So that's any type of violence between people that know each other and have been in a romantic relationship or related to each other. Any type of violence, interpersonal violence, is covered under Title IX, as well as domestic violence. Dating and domestic violence together make up interpersonal violence. Stalking is the most recent addition to the list of Title IX protections. Stalking is any course of conduct that causes someone to fear for their safety or suffer substantial emotional distress. It's a course of conduct, so it means it's something that's happened more than once, where someone has followed someone, surveilled them, harassed them, intimidated them to the point that they suffered fear or felt fear or suffered some sort of distress. So supportive measures under Title IX. Our policy and the new regulations tell us that the first thing that we have to do whenever we get a report is that we have to immediately reach out to the victim in the case and offer them supportive measures. And these are individualized services, and they can get these services without filing a report. They don't have to file a report to get these. It's something that we can do to make sure that they feel safe, to make sure that they're secure, and to reduce the trauma and what they're going through while we resolve the complaint. So these are things like counseling, academic and residential accommodations. So we can provide significant academic accommodations for someone that's dealing with the trauma of sexual violence, the ability to drop classes without penalty, the ability to medical withdrawals, extra test taking time, whatever it needs that they need academically to succeed in light of the trauma they're going through. We can provide those services. Confidentiality. We do maintain confidentiality when we provide those services. So there are some supportive measures that it would be necessary to talk to someone else. We would have to talk to someone else in order to provide that service. So for example, if a student needed some academic accommodations, they needed extra test taking time, they needed to drop a course without penalty, of course we would need to communicate with the instructor in that situation, so that we could let them know, what was going on, that we were asking for this accommodation for Title IX reasons. But in those cases, we will reach out to the complainant and let them know that, hey, this is where we will have to speak to your professor and ensure that they understand that we keep things confidential. And if we need to speak to someone else, that we're going to let them know ahead of time that we need to speak to someone else. Retaliation prohibited under Title IX. This is very important because this is one of the reasons that most people give for failing to report, and why they do not want to report is because they feel that there is going to be some sort of retaliation against them if they file a report. Retaliation is strictly prohibited under university policy. You can't intimidate, harass, threaten, coerce, discriminate, take employment actions against someone because they have either filed a report or because they have provided information. For example, witnesses. Sometimes witnesses don't want to speak because they're afraid there's going to be retaliation against them. It applies to all the parties. We do not allow retaliation. If anything occurs that is that the victim or the witness would consider as retaliation, we encourage them to report that to us, because we're going to take immediate action on that to reduce that and to eliminate that. So no retaliation under Title IX. So what does our grievance process look like under Title IX? Here's where the bulk of the new regulations come into play, because the process now under Title IX is very strict. It's very strict. It's very rigid. And the reason that the Department of Education gives us for that is because they want to ensure that we are providing a process that is not biased, that ensures the due process rights of everyone involved. So there have been a slew of legal challenges, lawsuits against universities since 2011 in those Dear Colleague letters claiming that the university's process was biased, that it was not fair, that universities were acting under the old regulations out of fear, that they were going to be punished for not following them, and that the defendants in that case were not getting a fair shot. So the new regulations address those and address a very formal grievance process that we need to take to ensure that there is no bias and that there is no elimination of anyone's due process rights. So the first thing that they did is they distinguished between a report and a formal complaint. So in the past, when we got a report, and that report could come from anyone, it could come from the victim, it could come from a third party. Most of our reports did come from third parties. It would come from a faculty member or an RA or a friend or someone that the victim had told, and then they would make that mandatory report. Under the old process, we had an obligation once we received a report to initiate some sort of action. Under the new process, in respect for what the victim would like to see occur in these situations, we require a formal complaint. So that means if we get a report from a third party, maybe a victim tells us a teacher and the teacher makes their mandatory report, we would first reach out to the victim, offer the support services, and then ask them, do they want to file a formal complaint? And it's the formal complaint that starts off the grievance process. Once a formal complaint is received, then we will immediately initiate that grievance process. And that includes providing written notice to both parties, initiating the investigation, considering whether we have to dismiss or remove somebody from the institution, discussing informal resolution options, conducting an investigation, conducting a live hearing, and then their appeal options. Kind of a flow chart for how that looks is we receive the formal complaint. The complaint will either be, the complaint can only be made by one of two persons. So anyone can file a report, but a complaint must come from the victim saying that they would like for the university to investigate and resolve what has happened to them. And then the only exception to that is the Title IX coordinator, I myself, can file a complaint if the victim does not want to, in cases and only in cases where it represents an immediate safety threat to someone else here at the university. So there, 99% of the times, if a victim does not want to go forward with a formal complaint, then we will not act against their wishes and go forward with a formal complaint. The exception is if we have evidence, maybe a pattern of behavior, maybe the person accused has been accused a few times of the same type of conduct, and we think that that is a credible threat to someone here at the university, safety threat, then there are those exceptions where the Title IX office can initiate a complaint. After that notice of complaint, we do provide the supportive measures to the respondent as well. So that's the person accused. Again, with the due process, we have to provide supportive measures to both parties. We'll let them know their rights and their options, the resources available, provide them notice of kind of what that grievance process looks like. And then we have to resolve the complaint. And that's either through a formal grievance process, which will go through an informal resolution, or a dismissal of the complaint. So emergency removals under Title IX. So this is a significant change as well. So there were, in the past, not here at UT Tyler, but at some institutions, the immediate response of an institution to someone being accused of sexual assault was to immediately do an interim suspension. Or if they were accused of stalking or any one of the sexual misconducts, a lot of institutions got to where they would just immediately interim suspend the student accused of that behavior until it was resolved. The new regulations say that we can't do that. That is not in the interest of, that is not following our due process rights, that the accused has a right to have all the evidence considered and a finding made against them before the university takes any sort of disciplinary or punitive action against them. There is one exception, and that is an emergency removal If we have evidence, again, that this person is a significant threat, represents an immediate threat to someone else's safety, then we can do that emergency removal. But outside of that, then we do have to go through the process completely, and that person must be found responsible before we can take punitive or disciplinary action against them. So the new regulations state that there are certain mandatory dismissals that we must do. We have to dismiss a complaint when the conduct alleged does not meet the definition of sexual harassment, when the conduct alleged is not within the university's educational programs or activities, it's not against a person in the United States, or the person, the complainant, is not affiliated with the university in that they are participating in or attempting to participate in the education program or activities of the university. So those are times that we must dismiss. Additionally, there are times when we can dismiss. If the complainant wishes to withdraw their formal complaint, then we may dismiss it. If the respondent, the accused, is no longer enrolled or employed with the university, we may dismiss it. Or if there are specific circumstances that prevent us from being able to gather sufficient evidence to reach a determination, that is a situation where we may dismiss. An example of that is, suppose we got a sexual harassment complaint and it said, 15 years ago when I was a student there, this professor harassed me. And we were not able to gather any evidence because everyone involved with that professor and witnesses and everything were no longer employed with the university, and there was no record going back 15 years. That may be a situation where we would have the discretion to dismiss. Dismissing a formal complaint under Title IX doesn't preclude an institution from addressing conduct prohibited under an institution's policy. So again, just because we say, well, these are things that we have to dismiss under Title IX, doesn't mean that there's nothing we can do about it. These are still egregious actions that the university needs to take action on. And so we will proceed under other policies, which I'll list here in a little bit, and we will still resolve those. It just won't be under Title IX. It will be as a violation of the university's policy. So there is the opportunity to do an informal resolution. That would have to be something that both parties agree to. And in that case, you wouldn't have a full investigation or adjudication. It could be a mediation. It could be a facilitated discussion. It is not allowed in cases where you have a employee accused by a student. There's just too much there of a power differential there to allow for an informal resolution. But in other cases, we do have that option. If someone would just like to, both parties kind of agree to, well, if this occurs and this occurs, that would satisfy, that would resolve it for me, and we get both parties to agree to that, then that is one option, is we have an informal resolution option. This is kind of the process, the grievance process that we're talking about here, where notice is sent to both parties. There's an investigation. We look for dismissals and emergency removals, informal resolutions. An investigation is conducted. At the end of that investigation, all evidence is shared with the parties, so that they have equal right or equal access to all the evidence in the case. Then it would go to a live hearing, and then at that hearing is conducted by a hearing officer who oversees that process and who makes a determination as to whether or not a policy violation has been committed. After that hearing officer determination, both sides can appeal. So if the person is found not responsible, the complainant can appeal. If the respondent is found responsible, then the respondent can appeal. But both again, due process, both sides have equal opportunity to the evidence, to the hearing, and to an appeal. So under Title IX, all the parties, the respondent and the complainant, have the right to have an advisor of their choice present to be with them during any interview, during any meeting, and also to speak on their behalf at the hearing. So with the new regulations and the requirements for live hearings, one of the serious concerns is we would not want a victim of sexual assault, sexual harassment to be directly questioned by their abuser or their accused. Okay, that's There's nothing good about that. So that is not a process that we want. At the same time, Department of Education says, but we do require cross-examination, because in their view, that is the only way to that is the best way to arrive at truth and ensure due process, is if we have both parties have the ability to question the other party about the evidence in the incident in question. So the solution for that was to make this a duty of the advisor. It is the advisor who would speak at the hearing and would ask questions of the other party. Again, they have the right to choose any advisor that they want. It can be an attorney, it can be a friend, it can be a family member, it can be anyone that the party wants to serve as their advisor, can serve as their advisor. However, if they do not choose an advisor and it comes to a live hearing, then the university must provide an advisor for them. And we'll do so without fee or charge or anything like that. So live hearings, that is required in the new Title IX regulations. Again, both parties have to have access to evidence obtained. Each party's advisor is permitted to ask questions of the other. Those hearings, the whole point of the live hearing means that it must be live and in time, everybody at the same time. That does not mean they have to be physically present in the same room. You may have a situation where the complainant does not want to be in the same room with the person that they've accused of abusing them. We understand that. So we can do these virtually. It's still live, but we can have them in separate locations so that we can conduct that process. When it comes to questions, that was a severe concern, is what kinds of questions would the accused be able to ask the complainant. Again, the hearing is presided over by a hearing officer, and the way that process works is the advisor would present the question to the hearing officer. The hearing officer would determine if it was relevant or not, and then would direct or not direct the other party to answer. There are certain questions, sexual history and things like that, that are not allowed in that question. The final thing on the live hearings is that if a party or witness doesn't submit to questioning at the live hearing, then the hearing officer cannot consider any of their evidence submitted by them or any of their testimony in reaching a determination of responsibility. So we really need folks to participate in the process so that we can reach the right decision. Again, both parties must be offered the right to appeal, both the determination of responsibility, or if we have to dismiss it, a mandatory or discretionary dismissal, both parties have the right to appeal that decision. So campus implementation. So what are we doing? How are we complying with these new regulations? The first thing we do, of course, is we have our notice of non-discrimination on the basis of sex. We have that in all of our formal documents, and we have rewritten our university sexual misconduct policy through the assistance of UT System to make sure that we are in compliance with what the new regulations say. One of those new regulations is that we do provide in every presentation that we do want to make sure that you know who the Title IX coordinator is and how you can contact that person. That person is me. I'm Blake Bombard. I'm over in the office of Title IX. We're located over at the Ornelas Activity Center. You can feel free to contact me by phone, email, or through our website, either way. So what does our institutional sexual misconduct policy look like? It mirrors the new regulations as required, but it also covers things that aren't covered in the new regulations. So some of those things that no longer meet the definition of Title IX are still in our university policy, and we're still going to respond to those. Things like sexual exploitation, other inappropriate sexual conduct, as well as other violations that have to do with sexual misconduct, such as false information complaints, interference with the grievance process, and failure to report. We want to talk about those as well. So sex discrimination, of course, is any discrimination where someone is treated less than favorably because of their sex. And that also includes gender identity, pregnancy, sex stereotype. All of those gender identities, gender expressions are covered under the term of sexual discrimination. The reason that sexual assault and sexual violence, sexual harassment were included in Title IX is because those are forms of sexual discrimination. You look at sexual assault, that's the most severe form of sexual discrimination, but it all falls under that sexual discrimination umbrella, which is why it's applicable to Title IX. Retaliation, we talked a little bit about this earlier, but that's any adverse action taken against someone because they filed a report, because they gave witness testimony in a report. It is strictly prohibited. And anything that a party feels was retaliatory in nature, please report to us because that is something that we can take immediate action on and stop. Sexual exploitation. This is one of those categories that doesn't fall under Title IX, but still falls under our conduct, our policy of sexual misconduct. So sexual exploitation, we see this in various ways. A peeping Tom, for example, is sexual exploitation. But the most common cases, the most frequent cases that we see that deal with sexual exploitation are cases that involve the non-consensual sharing of videos and photographs of a sexual nature. So we have had cases where someone has shared someone else's video, and the video may have been taken consensually. Say two parties consent to a video, and then there's a bad breakup, and then one party shares that video with others without the other's consent. That is a form of sexual exploitation. Other inappropriate sexual conduct. So when we talk about conduct that is severe, pervasive, persistent, sexually or objectively offensive, what if you have that conduct, you had those types of conducts, but it doesn't add up to being severe, or maybe persistent or pervasive. Maybe it's the first time something has happened and that report is made. It doesn't meet the definition of sexual harassment, but it's still inappropriate for the workplace or for the classroom environment. So it is still a policy violation under our university policy. Things like unwelcome sexual advances, requests for sexual favors, comments, jokes, persistent unwanted sexual romantic attention, sexually suggestive visual displays, all of those things that are just inappropriate, sexual in nature, that's a violation of our university policy. If those things continue to the point that they are persistent and pervasive, then that other inappropriate sexual conduct can become sexual harassment. So false information and false complaints. One owner should be aware that any person who in bad faith makes a false complaint or provides false information, that is a policy violation. They would be subject to disciplinary action in that case. We do want to note that just because someone is found not responsible does not mean that the complainant filed a false report. It just means that there wasn't evidence to sustain the allegation, that those are not the same things. Interference with the grievance process. Again, anyone who attempts to prevent an individual from providing testimony, removing or destroying documents or evidence, or knowingly providing false material is interference with the grievance process. That is an additional policy violation. So what has not changed under the new regulations is an employee's responsibility to report. So we are all responsible employees. Under Senate Bill 212 last year, all employees of an institution have a mandatory duty to report. So all employees are responsible employees. That includes all administrators, faculty, and staff. Anyone who knows of anything that we've talked about, sexual assault, stalking, violence, harassment, sexual exploitation, if you have information that has occurred, and then you have that duty to report to the Title IX coordinator. Failing to report under Senate Bill 212, any institutional employee that fails to report, they are subject to disciplinary action, they are subject to criminal action, and they are subject to termination from the university. And that is a must terminate, not may terminate. So that is the law. That is what we have to comply with. So if you're made aware of that happening, you're an employee of the institution, please make that report. Title IX coordinator outreach. We talked about this a little bit earlier. But once a responsible employee submits a report, then we do have that obligation to contact the complainant, offer them the supportive measures, and provide their rights and options under the law. Just know that a responsible employee's report to the Title IX coordinator doesn't automatically initiate the grievance process. Again, we do need that formal complaint from the alleged victim to proceed with a grievance process. What are the parties' rights in this process? So the complainant and the respondent have the following rights, during the grievance process: to be informed of and have access to any supportive measures, medical measures, to receive prompt, fair, equitable, and impartial grievance process, to receive information, ask questions about the formal and informal process, to be given equal opportunity to participate, including the opportunity to identify witnesses and other relevant evidence. Parties have the right to not participate. If they don't want to actively participate in the grievance process, they don't have to. We can't require them to do that. They have the right to have an advisor of their choice present. They have the right to that advisor representing them at the hearing to ask questions, and we will appoint one if they do not have one. They have the rights to to inspect and review all evidence and to receive copies of the investigative report. They are to be equally informed of all determinations that are made regarding responsibility. If there's a dismissal, they have the right to know that and why, and they also have the right to file an appeal. And they have the right to file with local or campus law enforcement activities. So we like to always stress that, because a lot of the sexual misconduct things that we're talking about are also criminal in nature. So we inform the victims in these cases that they have the right to file with law enforcement. They have the right to decline to file with law enforcement. And they have the right to our assistance, our office's assistance with that process should they decide to file criminal charges. So we've talked heavily about the Title IX grievance process that's required under the new regulations. And we've talked heavily about how what constitutes sexual harassment has narrowed from where it was in the past. But I do want to provide that there are alternative grievance processes for things that no longer fit under the Title IX definition. And we are not going to say that just because this does no longer meet Title IX, the university doesn't have a responsibility to address it. We do still have that responsibility, and we will address it. And we will address it either through our sexual misconduct policy, which has an alternative grievance process, or through our student code of conduct, Chapter 8. For faculty and staff, there's an alternative grievance process as well under our sexual misconduct policy, as well as grievance policies and procedures under other university policies. So just because it doesn't meet Title IX technically anymore, doesn't mean that there's nothing that we can do. We are still going to address any incident of inappropriate behavior, sexual misconduct that occurs. Kind of how that process looks, once we get a formal complaint, it starts down that Title IX process. But if we find that there is a formal dismissal under Title IX, or a reason that we cannot proceed under Title IX because it doesn't meet those regulative definitions anymore, then we kind of take that alternative grievance process. What that looks like depends on the process that we take, but it's very similar to the Title IX process. There is the option for not having a live hearing. If it goes that process, there can be an administrative decision made if the parties want that. If the parties want the live hearing, they can have the live hearing. As long as the informal resolution routes are available, and they're all alternative processes. So just because it doesn't meet that Title IX highway anymore, we do have these alternative grievance processes that we can use to resolve any complaints that we get. Lastly, we want to talk about campus support services and resources. Sorry about that. Let me see if I can get back to my screen. Okay, so our campus support services and resources. Making sure that we have equal access and opportunity to both parties, and that there are a number of things that we can do, whether or not they wish to file a formal complaint, that we are going to do whatever is necessary to provide for their safety, to provide for their security, and to help them succeed as students, having gone through the trauma of sexual violence or sexual harassment. This can include academic advising and accommodations, counseling services. We have emergency housing available, financial aid, medical and health services. We have a good working relationship with both Christus and Trinity Mother Francis for sexual assault forensics exams. If a victim would like to make an informed decision and talk with one of the nurses that conducts those exams, they've made their contact available to me 24 hours a day. We can put them in contact with someone that can give them the information so they can make an informed decision on that. Disability accommodations and services. So we work personally with the SARS office as well to make sure that if one or both parties has a disability issue, that we're addressing any sanctions, we're addressing any accommodations for both parties. Employment-related support. So again, Title IX applies to faculty, staff, as well as students. And we have employment-related support as well through the Employee Assistance Program. So the same things that the students get, like counseling, is available through our Employee Assistance Program. Safety, law enforcement, and escort services, especially when we're dealing with cases involving domestic violence or other forms of violence. Providing that person with a safety plan, whether it's escort from class, whether it's financial safety, how to get out of an abusive situation. Sitting down with someone and making those plans and providing those services is something that we do. And then victim advocacy services. So we have a couple of folks here at the university who work directly with advocacy, but we also have a partnership with the East Texas Crisis Center to provide advocates. These are folks that are available 24/7. 2 a.m. in the morning, someone needs to go to the hospital for a sexual assault forensics exam. We have advocates in the East Texas Crisis Center that will be there, and we'll be with them every step of the way, whether that's through a Title IX process, through a criminal process. We have those services available. Again, these services are available to the respondent as well. Providing advisors for hearing and providing advisors for hearings. So let me stop my screen share there. So that's kind of a highlight of, I call it a highlight. It's a lot of information from the new regulations, but it's something that we do want all of our faculty and staff to be very well aware of. You may have seen the most recent newsletter that Beverly Golden Marketing Communications put out, and it had a list of our new policy, a link to our website. We want everyone to be aware of what those are, where to find that information, and what the process looks like. Because when a student comes to you and reports what has happened to them, and you make that report, it's helpful if at that initial meeting with the student that you're able to provide that service, because there may be a chance that they don't ever want to talk to us. But if they have that information ahead of time, maybe they'll feel more comfortable making a report, talking to us, or at least they'll have the information on their own to seek services and resources that otherwise they might not have known was available. So that's the Title IX regulation update. If there's any questions, I'd be happy to take them. All right. Well, we do appreciate you joining us today. I encourage you to share this information with your colleagues. These Zoom sessions are being recorded. So if you think that this information will be helpful for your department, for your team, contact me. I'd be happy to provide that and share that, as well as doing any type of in-person meeting or training session that you would like. I'd be happy to provide that as well. So did anyone have anything? Did you have anything, Kim?
No questions on chat. Everybody's just saying you did a good job.
Well, I appreciate it. Thank y'all, everybody. And I hope you have a great day. Thanks.